SJC-13075, Commonwealth versus Aaron Almeida.
Okay, Attorney Shaw.
Thank you, Your Honor. May it please the Court, my name is Robert Shaw. I'm privileged to appear today on behalf of Aaron Almeida. My intention this morning is to reach as many issues as I can, beginning with jury selection and potential juror 101. Before addressing the core facts of that issue, I want to briefly reference 2 points of relevant essential context. First, there is overwhelming empirical evidence of historical differential treatment in our judicial system relative to African Americans, and that's inextricably linked to a long history of racial oppression in our society. And second, there is extensive empirical evidence that as a result of that history, African Americans hold beliefs that are more critical and scrutinizing of our criminal legal system than other groups. And the obvious implication of that is that if you allow the exclusion of African Americans because they hold beliefs that are more critical and scrutinizing of our legal system, then you are insulating
Can I just ask you about
treatment.
this particular prospective juror? Seemed like from the back and forth, that person didn't say anything about his own experiences. He talked about experiences that he had seen on TV, right?
Well, he talked about being informed through the news and the like.
But he specifically said, you know, not that I've had any.
That's correct. So he was asked a question about evaluating the credibility of police officers. In response, he made the factually true statement that police don't always tell the truth. As a result of that statement, the judge asked him whether he had a bias. He affirmed unequivocally that he did not have a bias, and that he would impartially evaluate the evidence and base it only on what he heard in the courtroom. The judge continued to press him as to the source of his belief, and he said he had awareness of cases and case outcomes where there was a lack of truthfulness. And it was on that basis that the prosecutor sought to exclude him from serving, not because of his accurate belief, but supposedly because the foundation for his belief wasn't legitimate. The prosecutor actually mischaracterized what he said as he saw something on TV and therefore police did something to the evidence, and that's not what he said. What he conveyed was an informed awareness of cases and case outcomes from news and the like, a perfectly appropriate way for forming beliefs, as any informed community member would. And I think there are basically 5 distinct reasons why allowing the strike was error. First, the prosecutor's explanation for the strike didn't meet the test of being adequate and genuine. With respect to adequacy, an explanation based on a mischaracterization isn't clear and reasonably specific to what the juror actually said. And as you point out, Chief Justice Budd, the source, this explanation concerned the source of the juror's statement, not his belief itself. And the source of his statement, how he formed it, had no bearing on this particular case or this juror's ability to be fair and impartial.
I'd like to probe that because I'm still struggling how you're going to divorce the source from the belief. So if on the questioning by the judge at sidebar is, why do you think this? And the juror says, well, I've been informed by what I've seen and what I've heard about other cases. Now, we're lawyers, and we know that that's informed by the evidence that's provided at the trial, which this juror would have no knowledge of. So that whatever it is that he's come away with in terms of the source of his information isn't based on anything. So if I turn around and say to you, I believe that police lie because of what I've heard about other cases, but I wasn't in the case, I didn't hear the evidence, I don't know what the foundational basis is for that. Why isn't that a proper basis to say that that's adequate?
Well, again, he's being asked a question about police officers specifically, and so his response is focused on police officers. Sure. He's being asked the question, which was really a poorly formulated question, would you evaluate police officer testimony in the exact same way you would evaluate another witness's testimony? His natural response, as well as Juror 92 later, was simply, well, you know, police officers, he's focused on police officers, his belief that, well, police officers don't always tell the truth, okay? That's all he's saying. When you look at the dialogue and you really review the whole thing, there's absolutely no reason to believe that he has some strong view about not being able to believe police officers, you know, generally speaking, relative to other witnesses. I mean, there's absolutely nothing about this individual that would provide a legitimate reason to want to strike him. And what we have in this record is
Even if the juror, again, this is different than the question you were asked by Chief Justice Butt. It's not as if he said, here's what I know from my own personal experience. His answer was informed by things he had heard and seen in other contexts that he had no specific detail of. So
right.
I'm asking, how is that an inadequate basis for the Commonwealth or the judge to conclude this isn't potentially a juror that will evaluate the credibility of the witnesses fairly?
Well, first, I think that how is anyone going to be informed? I mean, the notion that a juror needs to have personal experience of police lying, that would probably be a reason to prohibit him from serving. We all are informed in that manner. We're informed general knowledge of the community. We read the papers. We're informed by events. I don't think that's a basis to exclude him. And here, when you look at this record, was this an adequate explanation? Well, no, it was. The prosecutor is mischaracterizing what he said with respect to being genuine. I mean, if it's a genuine explanation, why mischaracterize what the juror said?
Isn't this whole back and forth, though, completely divorced from the purpose of the process, of the Batson-Soros process? My point is, it wasn't about, it doesn't appear to have been about the race of the prospective juror. You know, now we're talking about, well, was the comment by the juror mischaracterized? It was about something completely different, and so we're talking about a peremptory challenge.
But it is about the juror's belief that police don't always tell the truth.
In your brief, you're very critical of the question of the same credibility, in the same manner question.
Yes.
You've read a heck of a lot of transcripts in your time.
Yes.
Is that question's asked by just about every Superior Court judge?
I don't think in that form, not in my experience. I mean, to ask the question, you know, will you assess the credibility of a police officer in the exact same way? I think that these.
I think the question seeks to say that police officers don't always tell the truth, so you have to look at them as people, not by position. Correct?
Yes, and that's what the juror said.
And that's an appropriate question to ask the jury.
Yeah, and that's what the juror said. Actually, he said, "I would judge the police officer individually."
So, given that, what was wrong with the way that this judge asked that question?
Well, I just think phrasing it as in the exact same way. I mean, because you have to look at each witness in an individual manner, and it depends on the circumstances. With the following juror, you know,
if the judge had said, "Would you be able to assess the credibility of a police officer in the same way as a civilian witness," that would be fine?
In a fair and impartial way, yes. Can you treat?
Okay. It's her add-on in the exact same way that's problematic.
Right. Exactly. That's confusing. It's confusing, and that's why this juror made the comment. You know, police don't always tell the truth. That's why Juror 92 made the comment. Well, you know, sometimes police are involved in situations where there's stress, and it might affect their perception and how they see things.
Doesn't that suggest that the question wasn't confusing? Doesn't that suggest that the potential jurors were taking the question as intended, that in relative to a civilian witness?
I don't think that I don't think it was confusing as in they didn't understand it, but I think that's why their responses were focused specifically on police officers, and that's sort of the way they couched the answer. And I don't think that couching the answer, focusing on police officers, whether it's saying, police don't always tell the truth, which everyone acknowledged at the trial was an accurate observation, or saying that, police might have issues with stress and perception. I don't think that's a reason to exclude anybody. Now-
I thought your argument in your brief was a little bit different than what I'm hearing today, but I may be wrong. I thought you were arguing that for certain people in the jury pool, maybe I'll just say black or non-white, I don't know what the pool exactly would be. The fact that they answer in response to voir dire questions, that they have skepticism about the credibility of police officers should be weighed differently because of their race.
Well, so what I'm saying, Your Honor, is that if a juror has views that are more critical and scrutinizing of the legal system, that shouldn't be a basis, a race-neutral basis for which to exclude them. Now, I think that, that's...
So I have trouble unpacking that.
Okay, well, I think that's part of what we're asking the court to do and to look at, to create a very simple and sensible rule that
So
says
if a
that...
white person, a white veneery person said, I really basically don't believe police officers at all, the judge couldn't
No, that's a different...
excuse
that's-
that person for
Well, that's
cause?
a different type of question to say, I don't believe police officers at all. That's a very extreme question, which
I'm not
indicates
talking about question.
bias.
Let's just assume that the judge asked the identical question as was asked here. Would you assess credibility in a different way? And assume a white person answered exactly the way Juror 101 did. You're saying that the judge could not have determined from that Juror 101 was indifferent?
I think that wouldn't be a basis to exclude or strike the juror.
So this is Williams, right?
Right. This is Williams, exactly. And so with respect to what we're asking the court to look at is I think it's sensible for the court to say that where there's a source challenge, jurors having beliefs that are more critical or scrutinizing of our criminal legal system won't be accepted as an adequate race-neutral ground unless
Williams
it interferes with impartiality.
Williams had nothing to do with the race of
I'm sorry?
Williams had nothing to do with the race of the
I understand.
veneery person, correct?
Yes, I understand that, and that was a for-cause challenge. But just turning back to this for 1 second, because in addition to what we're asking the court to do in terms of looking at this rule, when you look at this record, I don't think there was adequate and genuine, it didn't meet that standard. The judge summarily ruled by making an inadequate conclusory statement that she finds the reason given is adequate. She didn't really expand on that. The judge revealed she didn't even credit the prosecutor's explanation, stating that she disagreed that he was basing it on a TV show. The judge then went on to provide her own reason for the strike, that he hesitated when answering, which isn't corroborated at all by the record, and wasn't offered.
How's the record going to corroborate hesitation or tone of voice?
Well, I mean, I
And
think
we defer to
sometimes
judge-
you can tell
Well,
on the
if you could-
record
if you
when
could-
there's...
If you could just wait and let me finish my stammering question before you answer it. How is the record going to substantiate a judge's finding, which we defer to because they're there, especially in this light, if a juror hesitates? The cold record isn't going to show hesitation, tone, attitude.
Of course.
Correct?
Of course. But, sometimes on the record, There are, for example, the judge refused to strike the juror for cause based on the notion that there was hesitation. That gives you an indication that it's not corroborated by the record. Also, sometimes in the trial record, there's a back and forth that indicates that somebody is actually struggling, and you can see the ink on paper, and it sort of is apparent. What I'm saying is that's not apparent here. And then, the judge goes on to state that one of the reasons that she's allowing the strike is because the juror didn't explicitly state that his beliefs were based on his own race or ethnicity, and I think that's an improper lens through which to evaluate the prosecutor's explanation. I've not seen that in any case, in any jurisdiction, and I think it highlights the fact that the judge wasn't engaged in a critical evaluation of the soundness of the explanation and its actual motivating force. I don't have much time left. I wanted to address the other juror issues, but I'll move on to the voir dire issue because I think that's an important one unless the court has questions.
Can you ask me what the judge was supposed to do? So the defense attorney says, basically, gotcha, I move for mistrial on perjury grounds, and there needs to be an inquiry at that point, correct?
No.
Okay, so tell
What
me
she
what should have happened.
She went to sidebar and she requested a
A mistrial.
Yes.
Right. And the judge is supposed to make a determination of mistrial based upon what was just testified to. But the judge has to find that the witness has in fact perjured himself.
Right.
Without further inquiry.
Right. Well, so basically, what the trial judge was called upon to do when defense counsel went to sidebar is determine whether at that point in time she had established what she was asserting, which is that he was committing perjury.
Right, but how is a judge to know all that the defense attorney knows? Because the judge knows what the answers are, and then the defense attorney says that's perjury because of X, Y, and Z.
Right, and
And the judge is supposed to assess what the defense attorney just told the judge and then say perjury or not perjury?
Well, I mean,
Without further inquiry.
at that point in time, counsel believed that she had established it. She
Well,
went to sidebar.
Sure.
She indicated the basis. She wanted the noise put on so he wouldn't hear it. The judge basically disagreed. I mean, the judge disagreed. Now, what the judge was called upon to do at that point in time was rule. And if
But what if the judge isn't comfortable making that rule and it needs further information? Does the judge have a discretion to hear more facts to determine whether or not the witness has in fact perjured himself?
It's not over objection. I mean, defense counsel, this is a first-degree murder trial.
I kind of know it's a first-degree murder case because we're here on a Friday.
Yeah.
All right.
And I'm just emphasizing, and she's in the middle of her cross-examination, and she objects. I'm in the middle of my cross-examination. So if the judge rules at that point in time, based on her request, that there isn't a mistrial, then she should have the opportunity to continue her examination and see whether she can undermine his credibility with the information she has. The problem here is that the judge then allows a voir dire. She does it.
What's the purpose of the voir dire that she states?
Well, she rationalized the concern that defense counsel might convey in further questioning against the interests of Mr. Almeida, that Almeida had been arrested and incarcerated previously, something that counsel had explicitly taken care to exclude from the trial, something that the prosecutor had clearly told the judge he had been instructed not to speak about at all when he was testifying. So allowing this made no sense. It was inimical to the truth-seeking process, and it really tainted and interfered with the right of confrontation and basic fairness. And, then there's this other element that then once we get into the voir dire, the prosecutor is revealing the information that defense counsel possessed in order to undermine credibility, and then he changes his testimony.
So why isn't it the case that, if you're correct, every time defense counsel has a really strong basis for impeaching testimony of a witness, defense counsel can just say, Your Honor, I move for a mistrial that the witness is perjuring themselves, and then the judge has to try and figure out whether there needs to be a mistrial because of perjury, and then has an inquiry. I mean, they can't rule, unless you're saying that a judge has to just issue on-the-spot rulings about perjury. It seems like the judge has to make an inquiry, and then you're saying the very fact of the inquiry has defeated the defendant's confrontation rights.
Right, because counsel at that point went to sidebar. Perhaps she went to sidebar a little bit early. She provided the evidence that she had. She had asked the questions in her cross-examination that she believed established it. The judge looked at it. The judge didn't see it, wasn't going to allow a mistrial, didn't find that he was committing perjury. And so at that point, the question is, does the judge get to intervene into the proceedings, cut off her cross-examination, give him a dry run without the jury present?
Well, she cut off her cross-examination.
Well, she went to sidebar, but she did not want to have a voir dire. She was objecting clearly to the voir dire. She wanted to continue her cross-examination. She said, Judge, I'm in the middle of my cross-examination.
But that's not her call. I mean, we all know we have different roles in this. And so to the extent that defense counsel raises this issue, how the judge in their discretion then deals with the issue that was prompted by the sidebar request. You can't say I'm the lawyer and I'm going to be the one that raises it, and I'm also going to be the one that determines how we're going to deal with it.
Well, I mean, the judge, I think the point here is that the judge did deal with it. She ruled that I don't see perjury. And then, there was a question about having a sidebar. The judge was thinking about it. Defense counsel was objecting. And the judge went on with it anyway, based on reasoning that really didn't make any sense at all. And the problem when she did that is that she gave him a dry run, and she allowed him to learn of the information that she had, because the prosecutor, I think, improperly provided it to the witness. And then he completely changed his testimony. And when you look at his testimony pre-trial, when he did a voir dire, and then you look at it, even some of the testimony during the, this voir dire after the sidebar, he was not testifying truthfully.
You know the record certainly better than I, because I didn't dive into it as deeply as you have. But in terms of the issue of whether the judge made a determination that there wasn't any perjury, you're saying when we go back and look at that record, it was unequivocal, unmistakable that when this was brought up by defense counsel, the judge said, there's nothing to it, no reason to go any further.
I think, and I'm glad you asked the question, because I think it's important to clarify. Prior to trial, when determining whether he could give a video identification, his testimony was false. He was at best exaggerating, and at worst it was false. When he testified at the trial proper and defense counsel began her cross-examination, I agree that her questions were imprecise, and she was not precisely indicating the timeline to the point that I think the judge made the correct ruling when she did at sidebar that I don't see perjury. I agree with that. Yeah, but I mean, overall, then when they have the voir dire after defense counsel goes to sidebar, there are instances where he affirms that what he said previously.
But apart from that, it's her purported rationale is I don't want him to disclose the arrest and conviction in front of the jury, correct?
The judge's rationale.
The judge's rationale.
Yes.
Right. And you may disagree with it, and you may say there's no way this experienced defense attorney is going to expose the witness to that or the jury to that, but the judge doesn't want to risk that. That's a judge's discretionary call, right?
Well, Your Honor, I just think that goes too far. I mean, defense counsel, it's like saying, I'm not going to let you continue with your, cross-examine him in front of the jury because I'm afraid you'll disclose something that defense counsel is taking care to exclude and that the witness has been instructed not to speak about. I just think that doesn't make much sense. I mean, this is the way that defense counsel has to represent her client and bring out an accurate judgment of credibility. This is it. She's got nothing else. So If there are questions about any other issues, I know there are a lot of them, I'm happy to address it. Otherwise,
Okay, thank you.
thank you.
Attorney McLean.
Good morning, may it please the court. Ian McLean on behalf of the Commonwealth. Your Honor, I'll start with the issue you just ended with opposing counsel, the voir dire of Officer Flaherty. The timeline is really important in analyzing this question. Attorney Scapiccio asked several questions during her cross. She was imprecise in the date range she used, and the responses from the officer were not perjury. And you just heard opposing counsel acknowledge that his responses were accurate based on the way she phrased her questions. She approaches sidebar, accuses him of perjury, demands a mistrial. The trial judge responds, based on the questions I heard and the answers I heard, I don't see any perjury. Your motion for mistrial is denied. At that time, we would have just gone back into the cross. But what happened next is Attorney Scapiccio persisted in her argument for the next 4+ pages of transcript, arguing, no, he perjured himself, I want a mistrial. The Commonwealth has an affirmative obligation to correct this perjured testimony. So at this point, the persisting in the allegation of perjury puts the judge in a predicament. It's basically a reconsideration at that time. The judge could have stuck with, nope, denied, we're going back into cross. But the judge decided to take this seriously and make sure that she hadn't mistakenly understood the testimony because the defense attorney was so adamantly arguing that it was perjury. At that point, there's really no option. The judge was well within her discretion. It was not outside the range of reasonable alternatives to conduct a voir dire and make sure that the questions posed and the answers given were not perjury based on the arguments the defense attorney was making. So what the judge did here was entirely appropriate. So turning back to the impanelment process.
Can you address, as it's relevant to issue 1 on the peremptory challenge, and certainly directly relevant to issue 2, how these cases are different from what we wrote in Commonwealth versus Williams?
Yes, Your Honor. So the first issue, the Batson-Suarez issue of Juror 101, is categorically different from Williams. Williams was for cause. My understanding of the Williams case is it's a juror is going to bring their own life views, their own personal experiences into the deliberations room, and that's appropriate. And that's not a reason to strike a juror for cause. And so here, the Commonwealth against juror number 101 did raise a for-cause challenge.
No, I understand that Williams was a for cause, but and we'll address that for juror number 92 on issue 2. But for juror 101, if this is a life experience of this juror, is it adequate and genuine for that to be the basis of a peremptory challenge?
Yes, it absolutely could be. It absolutely could be. Even if it was clear, take it out of this specific juror and make it more of a hypothetical juror, and they said, based on my prior experiences, I know that police officers tamper with evidence. So it was a personal experience as opposed to something he had heard somewhere. While his personal experience and belief as a result would be a Williams issue, that would not be a for-cause challenge. That could still be a reason why a party wanted to exercise a peremptory challenge. That reason could still be adequate and genuine.
So if a juror, hypothetically, if a juror had said, I take the Williams situation, if a juror had said during voir dire, I believe that people of color are treated harshly in our criminal justice system during voir dire, right? And there's a peremptory challenge. Is that adequate and genuine?
It could be. Well, so let's set aside genuine and assume that there is the actual reason the challenge
Right,
was
adequate's
made.
easier, right?
So the test for adequate is, was it clear, was it personal to this juror, and is it not based on their group affiliation? The way you just phrased your hypothetical, it was a clear response, and it was specific to this juror's belief or opinion, and it's not based on the fact that they are a member of any particular protected group. They just have a belief about how the criminal justice system operates.
But can't that end up being used as a proxy for race, if the person happens to be of color?
Well, I'm not sure why. I think there are people of all different colors and creeds and races and religions that have very strong views about the criminal justice system, both pro and anti. So I think it could be anywhere.
Well, then you get to genuine, right?
Yes, what you're discussing right now would absolutely be acknowledging whether this was the genuine reason the challenge was exercised, or if it was some implicit bias or subtext towards racism.
So what do we do about that?
Well, I don't think that the test needs to be changed at all. I think we're relying on the trial judge, as we do, because the trial judge sees the party that's exercising the challenge, and they are then assessing the credibility of that person that's exercising the challenge. And they're there in the room. They're seeing the body language, the demeanor, They're seeing it all, right? When we don't capture that on the cold record, it's impossible to. While we can listen to the audio and see and hear a hesitation, but we can't actually see. We don't have eyeballs on the person as the trial judge does, which is why this court has always vested broad discretionary authority in trial judges in evaluating and determining the credibility of the reasons stated for those exercising those challenges.
So when you're looking at adequacy and genuineness, is it that we're looking, that the adequacy is a question of law and the genuineness is subjective, and that's a finding for the judge?
Well, as to genuineness, absolutely. And I point the court back to Mathieu, I think was the last time that the court expressly articulated that the genuineness is essentially a credibility determination.
Adequacy? What about adequacy?
So the court's used a few different phrasings of how that is to be measured. But it's still, so I would point you to Prunty then from 2012. It's afforded great deference on appeal because it largely determines on a credibility determination. It's again, they're stating their reason and they're explaining the basis for it, right? So the
Isn't that a question of law, though? I mean, or at least mixed?
Well, you could call it a mixed, you could call the adequacy a mixed question, I suppose.
And what's your best case for, as the chief pointed out, this lack of a proxy if someone has a belief about the fair representation of the criminal justice system, and that's the basis of a peremptory challenge?
I'm sorry, I'm not
What's your,
sure that I-
any case law on that? What's your best case on that situation?
I'm not aware of a case that expressly addresses that, other than the cases that sort of generically articulate the test, that the test for whether it's adequate is whether it was clearly stated, whether it was personal to that juror, and whether it was not based on their group affiliation. So if a challenging party is unable to clearly articulate the reason, that could be a suggestion that this is actually a cover reason for an actual bias or an implicit bias, right? But, so that's why I say the clearness of the response is also sort of a credibility kind of determination, so that even the adequacy test is not just factual, there's also sort of a credibility assessment contained within that as well.
Can I just turn your attention to the question about the search warrant? I've got, there's two prongs, right, for independent source?
Correct, Your Honor.
Right, so one of the prongs is, would the police have done this anyway? Would they have searched the Sawyer residence anyway?
Correct, Your Honor.
How do you get around the fact that in the affidavit, the officer says, as soon as the defendant told us he lived at the Sawyer address, we saw the...
Well, you've left out a couple of steps there. So factually what happened is, and the other prong of that analysis is excising the problematic statement, is there probable cause?
Well, and we'll get to that, for
Sure.
sure.
If it's all right, I'd like to sort of start there because a lot of those facts are then relevant to the second question. So what else was in the affidavit to establish the nexus to the residence, the 92 Sawyer residence? First, members of the Youth Violence Strike Force saw him exit that residence at about 10 o'clock in the morning. They saw him get into a car that they ultimately learned was driven by his grandmother, and his child was in the car.
And this is a week after the
Correct.
murder?
Correct. I believe it was 8 days, but yes,
Okay.
a week. So what inference can we draw from that fact? That means other members of his family knew to find him there at 92 Sawyer Street. His grandmother picked up his child and brought the child there to acquire him to go to the beach. So other members of his family knew that he could be found at 92 Sawyer Street, is the first thing. After they stop the car and take him into custody, they have a conversation with the grandmother there at the scene. And the grandmother there at the scene says, "Oh, he lives at the other half of my duplex over on Silva Street." So what does the detective do? He immediately sends officers to freeze that scene. So that gives you an indication that he's now going to search wherever it is he understands the defendant to be residing, right? And that makes sense because what he's searching for is both the murder weapon and the clothes that the suspect was wearing. And there are a litany of cases that talk about we can expect both weapons used in crimes and clothing to be at the suspect's residence. So the fact that the detective is going to search wherever this suspect is living is clear. He does the interview of the defendant that's been taken into custody. When they conclude that, he goes to the Silva residence. At the Silva residence, they talk to the defendant's father. The defendant's father informs them, yes, he does live here, but he hasn't stayed here for the last couple of weeks. So now he's in a transient sort of state. He's not staying at that residence. So where is he staying? The officers had just seen him that morning coming out of 92 Sawyer. and other members of his family knew to find him at 92 Sawyer. They then go talk to the uncle at 92 Sawyer, and the uncle conveys, yes, he does stay here occasionally. He doesn't have a key, but he does stay here occasionally. And yes, he was actually here starting at 7 o'clock in the morning today. I saw him in the apartment at 7 o'clock in the morning. So now they have a reason to believe that he's not staying with his father, and he's been seen at 7 o'clock in the morning and at 10:40 in the morning at 92 Sawyer, and his grandmother knew that he was at 92 Sawyer. So at that point, it's clear that they're going to get a search warrant for that location as well. So that's basically the argument. It works in both of them. It helps establish the probable cause, the nexus to that location, and it explains why they would have gotten a search warrant for that location. They weren't prompted to get the search warrant for 92 Sawyer based on the statements the defendant made. After that interview, they went straight to Silva, the Silva residence, and that's when they learned, oh, he's not actually staying here, hasn't been staying here in the last couple of weeks.
Do you have cases that are similar to this where you've got that type of information for nexus? 'Cause it just seems like it's a week after the murder and everybody says he does not live there. So I was just wondering if you have any, what's your closest?
Well, I don't have a factual case that I would point to you as analogous, but what I have is it's reasonable to expect that both clothing worn in the commission of a crime and a weapon or a firearm used in the commission of a crime are going to be found where that suspect is residing.
For sure. But the question is whether you have enough to say that he resided there.
Well, we have a person who is in some sort of transient state, right? It's disavowed that he's living at the place where one family member says he's living, and then he is seen at another location, and members of the family know to find him there.
Right, and so that's what you have, and the question is that enough? Can I just ask another question about?
Absolutely.
I think in the motion denying the defendant's, the defendant's argument that the fruits, the clothing should be kept out, right? The judge said denied and then made a reference to a database in addition to some paragraphs in the affidavit. And I just want to, it seems like she was going outside of the four corners of the warrant. Is that a fair?
I'm sorry, Your Honor, I don't recall a reference to a database, so I'll have to
Yeah.
take a look at that, and if there's
Sure.
a citation I need to provide to the court, I
Okay,
will.
it's, it looks like it's page 60, or 71, I think, of the record appendix. Page 68 of the record appendix is the motion in limine, and it has a margin endorsement denied, and then it says, look at paper number 102. Paper 102 is page 71 of the record appendix. And there's an asterisk that says, including the observations of police officer, information from the database, and paragraphs 26, 30, and another paragraph, I don't know, it says 30 again, demonstrates that there was a nexus.
So, Your Honor, what I would say is that a lot of these motions were filed sort of once impanelment had begun, and there were a lot of litigation of issues that really, in best practice, would have been resolved weeks or even months before trial. So this is somewhat of a chaotic environment, which is why I think sometimes you see margin endorsements and then statements in the
I
record.
understand why it's margin endorsement. I'm just trying to figure out, within that margin endorsement, she references things outside of the four corners of the affidavit. So, for example, there's no indication in the affidavit about why they were there at that Sawyer address to begin with, to see him come out of there. It's just not there. There's nothing in the affidavit that explains that. And so is that a problem? Given the fact that we don't know why they're there, and the judge appears to have information that it's outside the affidavit that she used to deny the motion in limine.
Well, I'll look to see what she might have been referring to when she said database, but there's no database that was introduced in
Well,
evidence
I
anywhere.
I actually looked at it, and I think it had to do with, the police had information about where he grew up, which was that Sawyer Street address.
Well, I'd point you to, so within the four corners, I'd point you to paragraph 25, where the detective said he had basically 24 and 25. He had directed the members of the Youth Violent Strike Force to begin looking for the defendant, and then they went to that location. So I think
Right.
from that, you can infer that they were sent to that location. Now,
Why, but wouldn't the reason why they were sent there be really helpful for Nexus? It's just not in there. That's my only point. I'm not saying that they were wrong to go there. I'm just saying that if you are looking at the four corners of the affidavit, it's not there. That's it.
Sure, Your Honor, I'll concede that and agree with you that the reason that they went to that particular residence is not contained within the four corners. I mean, you could.
Do you think it's a fair inference from what is in the four corners of the affidavit that their presence at that address was not random?
Yes, Your Honor, because that was the apartment that belonged to his uncle, and they were sent there by the detective. So presumably, it was most likely an RMV search based off of known relatives. But that is an inference that would be drawn from the facts that are in the affidavit, and we do draw reasonable inferences that are possible from the affidavits themselves. But even if they had been there on a purely random basis, if they were just sitting there having a cup of coffee and eating a donut, and they saw him walk out of the apartment and get into a car and drive away, they now know that he was there. And then other places in the affidavit, it explains that he was there at 7 o'clock in the morning and took a shower there. And then we also know that the grandmother knew that he was there at that time. Those things alone would be enough to establish the nexus to the location. When his other potential residents, the people that live there, have disavowed him of living there for the last couple of weeks.
If, just say we disagree and that the clothing shouldn't have come in, what happens then? Because it seems like the clothing was pretty prominent. What's your best argument for it not being harm, the
Understand, Your Honor.
yeah.
So the clothing can be seen in the various video clips showing the defendant both approaching the scene and then fleeing the scene afterwards. But even if you remove the clothing from consideration, you have that person was identified by Officer Fuller from the poll camera clip, and then he was also identified by an ex-girlfriend of his, Brianna. I apologize, I'm blanking on her last name, but it's referenced in the Commonwealth's answer as well. She identified him from the video as well. So you have two separate people identifying the defendant in the video footage, and you have the cell phone call that he received from the driver of the car and the CSLI placing him in the relevant area, and the video footage actually showing him take his phone out of his pocket, answer his phone. So you have the CDR, the call detail records from both of those two cell phones showing the time of the call being placed, the video showing him answering a phone call, and the CSLI putting him in that same area. So even if there had been a problem with the search warrant and the clothes that were obtained, which there wasn't, but even if there had been a problem, he was identified in several other ways as well, above and beyond the fact that he had that Tommy Hilfiger T-shirt that you can see in the video footage and the ripped jeans.
Yeah, but don't you have to worry about whether or not that information was harmless beyond a reasonable doubt? So, I mean, the fact that it was part of the evidence, and it was, like you pointed out, it was pretty obvious in the video. If you take all of that out, don't you? How do you say that it wasn't harmless? That it was harmless beyond a reasonable doubt for the jury to have that information, and they shouldn't have.
Well, I was really clear that we do not at all concede that there was no nexus.
No, I understand. This is just hypothetically.
Sure. Then you have a piece of evidence that was introduced that was a problem. The reason that I think it's harmless is because the much more powerful evidence identifying him is two people saying, yes, that's him in the video footage. So now it's him in the video footage, and the video footage shows the shirt, and then in each portion of the video footage, you can see the shirt again. So the fact that that shirt is tethered to him is also tethered to him by two people that identified him. So that sort of negates the significance of where that shirt is then subsequently found. You also combine in the other corroborative facts, the cell phone call that's going to match up on the CDRs, as well as the CSLI putting him in that location at the time. So, Justice Gaziano, I believe you wanted to discuss Juror 92, the for cause challenge.
Yeah, and distinguish that from Williams, if you can.
Okay. I don't think, so here it's, as Judge Ames explained her reasoning, she explained that it was both the substantive responses that were provided by the juror and her observations of the body language, the hesitation, the demeanor. So again, she can see all of that. We can't see that on the record. But as to the substantive responses, this was a challenge because, or excusal for cause, because the potential juror would not unequivocally say, I can be fair and impartial. If you read the actual responses that were, the questions and responses, the initial answer was yes, in response to question 2 about the law enforcement credibility. The initial answer was yes. Clearly, there was some hesitation there because Judge James asked a follow-up question, and she asked, do you have a question about that? Juror 92's response, I have some misgivings about police officers and their ability to assess the situation when they're under stress. And so Judge James asked another follow-up question. Again, we have a hesitation. So you have some concerns, and the juror's response is, yeah. So that's not an unequivocal statement of I can be fair and impartial. And so there are several cases where a juror's refusal to give an unequivocal statement that they can be fair and impartial is a basis or a challenge for cause. So that was the actual basis here. Not that she held a belief or something. It basically fits within Williams. She's not unequivocally saying, I can set that aside and follow your instructions. So the question then becomes, we evaluate the judge's determination for abuse of discretion, and this was not outside the range of reasonable alternatives. And I'm sorry, I see that my time has expired. If there are no further questions.